All right, if you've been named as the successor trustee in somebody's trust, that means you've got to administer their trust. Typically, that might involve liquidating bank accounts, distributing assets, selling real estate. Maybe you got to set up a trust for a minor child, a whole host of things, right? Maybe you're in charge of funeral, cremation, all of that sort of stuff. But you got some stuff that you have to do. A lot of people kind of get overwhelmed by this. So I just wanted to kind of talk about 5 things that we see, hopefully 5 mistakes that if you have been named as the successor trustee and now you're the one having to serve as trustee, just 5 things to pay attention to. So number 1, violating your fiduciary responsibility. So you do have a fiduciary responsibility, which is the highest level of responsibility, meaning that when I think of this, I specifically think about finances. So if someone's got $1 million in an account, well, you have a fiduciary responsibility to manage that appropriately. You shouldn't probably go invest in your neighbor's startup company with that. You probably shouldn't use a whole host of brand new hot investments, maybe even Bitcoin or crypto or something like that. You've got a fiduciary responsibility to ultimately the beneficiaries, the parties to that trust. And so you want to act accordingly. Don't try to do some sort of get rich quick scheme or, try to flip that into something else. So you've got a fiduciary responsibility. Pay very attention to that. That's where a lot of people get sued. That's where a lot of trustees who are serving get sued for quote unquote breach of fiduciary duty. Number 1, conflict of interest. This one's probably pretty obvious, but check and see who the beneficiary is. Do you have any sort of conflict of interest where you wouldn't be able to act in good faith on the responsibilities? Maybe it's a real estate holding or it's a real piece of real estate and you've got a vested interest in like the adjacent piece of land, and so you don't want the building to be sold, or you don't want, you're afraid it might happen. So maybe it's not in your best interest to go sell that property, even though that's what the settlor, the person, the trustor, the people who set up this trust want you to do. So just check if you have any sort of conflict of interest, ideally before you even get named in the trust documents. Number 3, failure to keep good accounting records. Again, this is one I see a lot because you probably in good faith, you want everything to be done properly. Maybe you're even doing everything properly. The beneficiaries, though, they might not trust you, or maybe the relationship's a little bit sour at this point. So you want to keep a good accounting and provide that accounting to the beneficiaries, right? Keep track of everything. Keep track of what you spend, keep track of what comes in, keep track of expenses, keep track of everything. And most trusts and most states are going to require some sort of accounting that has to be provided to the beneficiaries. So make sure you're doing that. Again, a lot of litigation comes out of faulty records or not keeping any sort of records, and get out ahead of it, because I promise you, if there's anything involved, money, houses or whatnot, those beneficiaries are going to want to see it. So you don't want to wait a year, 2 years, and then try to go back and remember all that stuff. Number 4, failing to understand compensation. And what I would say about this is and explain it properly as well. Again, each state, when it comes to serving as the successor trustee, they probably have their own statutory requirement or statutory what you can be, what you could charge. It could be a percentage, or like in Florida or some other states, it could be, basically what's reasonable, which is very difficult to figure out sometimes. And the trust document itself might even say. But be upfront with the beneficiaries, because last thing you want is, you've done a great job, you've administered the entire trust, and now you're trying to get paid, or maybe you've been paid along the way, and now the beneficiaries start fighting. They hire an attorney to fight you on your fees. So just get ahead of it, let them know, hey, look, I'm administering this trust, this is what I'm going to be charging, this is what the law allows me to do, and just be out in the open on it. Which kind of brings me to number 5, is just don't try to go this alone. I see, you might very well even be an attorney. You might be someone who could reasonably handle these things. But again, the complexity is going to depend, but you're probably going to want an attorney to help you with it, at least with keeping up with making sure the proper notices go out. If anything needs to get filed, it gets filed. You probably want to have a CPA to review everything, to update the taxes. And if for anything, you want a team of professionals who kind of act as a buffer sometimes between you and the other beneficiaries, because it can get contentious. And if they think you're doing kind of shady stuff, it just can make things difficult. So again, provided that there's resources. I know sometimes people say, I can do it myself, but this is one of those things where you don't want to be penny wise and pound foolish, as the saying goes. Spend a little bit, that's going to come out of the trust most likely anyways, and it's just going to make for a much smoother situation, much smoother trust administration.